Good day everyone, I am Adrian Seres Diragay and I will be discussing the Module for Institutional-Based Corrections. And these are the topics that I will be talking about. Institutional-based corrections, structures, management, standards, programs, and services in the Philippines. Two system-based approaches to corrections. The Bureau of Corrections or RA 10575, custody, security and control of prisoners, care and treatment of prisoners, release of prisoners, good conduct time allowance or GCTA, prohibited acts subject to disciplinary actions, the BJMP or RA 6975, the Republic Act 9263, treatment of special needs or unusual offenders, emergency plans, movement or transfer of prisoners or detainees, privileges of detainees and sentenced prisoners. The Regional Rehabilitation Center for Youth, the Child and Welfare Code, the Death Row, and the Rule on the Writ of Amparo. So the first is the institutional-based corrections. So in the late 1980s, institutions for the confinement of convicts and the detention of those awaiting trial included a variety of national prisons and penal farms as well as numerous small local jail and lockups. In general, the national prisons housed more serious offenders and those serving short-term sentences were held in local facilities. The prison system at the national level was supervised by the Bureau of Prisons of the Department of Justice. So, institutional-based correction. So, this is an institution that confines convicts or detainees that has violated the law or they can be called law offenders. And they on the and they only the people that were confined in the in the detention cells were only those who were serious offenders. The Bureau was responsible for the safekeeping of prisoners and their rehabilitation through general and moral education and technical training in industry and agriculture. The Bureau also oversaw the operation of prison industries and the production of food commodities. In 1991, the newly formed Philippine National Police took over administration of local jails. So, this agency is responsible for the safekeeping of prisoners and they also provide rehabilitation and moral education, technical training in industry and agriculture to the prisoners. The government maintained 6 correctional institutions and penal farms. The nation's largest prison was the National Penitentiary at Muntinlupa, Rizal Province near Manila, which also operated the Manila City Jail. The penitentiary served as the central facility for those sentenced to life imprisonment or long-term incarceration. It was divided into 2 camps to separate those serving maximum and minimum penalties. The Correctional Institution for Women was located in Metropolitan Manila. Combination prison and penal farms also were located in Zamboanga City and in Palawan, Mindoro Occidental, and in several Mindanao provinces. Structures. This description of the correctional system of the Philippines covers laws, types of institutions, methods for obtaining early release and reduction of sentences, and proposals for system changes. 3 subsystems of the correctional system serve different types of prisoners. Those sentenced to more than 3 years, those sentenced to 6 months to 3 years or with pending cases, and those with lesser sentences. And to limit the length of incarceration, Philippines also uses absolute pardons, conditional pardons, commutations of sentences, amnesty, parole, and good conduct allowances. Correctional facility rules are designed to allow prisoners to develop personal and social relationships. A centralized jail system has improved control over the nation's jails. Special programs and 4 residential facilities provide services for youth development and for youths with special needs. Several task force and committees have proposed changes, including the establishment of a national organization to administer all correctional institutions, a more liberal system of release on recognizance, and the discriminalization of victimless crimes. Management. A review of popular industrial models of management indicates that they are only partially applicable to corrections management. Unique features of institutions such as their bureaucracy, finances, and inmates must be considered in developing a management style. The managerial models examined include management by objectives, organizational development, participatory management, the contingency model of management, and the traditional autocracy. So there are also managements around the correctional-based institutions or jails. The process of management, according to the models, to most models, requires the development of objectives. The text looks at defining objectives in a correctional institution in view of its main custody and treatment aims. Unlike the business sector, public correctional institutions must consider the input of interested groups for formal authorities, specialists in the field, the public, and the staff and inmates in formulating objectives. Other managerial aspects to consider in developing a style include the manager's power to operate the institution, the kinds of power that can be retained or delegated by the manager, and the control of power through the control of information. Special managerial problems involving employees of prison industries, both inmates and staff, are considered in terms of prison settings and constraints. These problems involve maximization of production, staff development, working conditions and fringe benefits, unionism, and group endeavors. Furthermore, the text discusses the constraints placed on managers by the governmental bureaucracy, which spells out the general policy the manager must follow, by finances, and by the community. Special consideration is given to two types of budgets: zero-based, factorial performance, and programming, and budget building, and to the ways of the public gets involved mainly through advisory committees and voluntarism. A final chapter discusses the inmates as they relate to the management style and addressing issues of inmate-staff interaction, prisoner grievances, prisoner rights, and prison conditions and atmosphere. An index and over 300 references are provided. For the standards, it is intended for use as a separate document by criminal justice system administrators, legislators, and other in need of a reference to the policy issues surrounding institutional-based programs and parole, particularly those related to cost and implementation of correctional standards. Included in the analysis are the 3 types of costs: criminal justice system public expenditures, most of which will appear in the correctional administrator's budget, external costs borne by the non-criminal justice agencies and private individuals or groups. It also demonstrates techniques applicable to estimating cost of alternative correctional programs for a particular jurisdiction. These reports covers separate analysis of standards of offender management, new, new and expanded programs and offenders' rights, typology of cost used in the analysis, and specific features of the report's cost estimates. Programs and services in the Philippines, correction and rehabilitation of penitent offenders to effect the rehabilitation and reintegration of probationers, parolees, pardonees, and first-time minor drug offenders as productive, law-abiding, and socially responsible members of the community through number 1, well-planned supervision programs for probationers, parolees, pardonees, and first-time minor drug offenders which are aligned to the national program thrust of the government, such as the Sariling Sikap jail decongestion. Next is the establishment of innovative and financially and technically feasible projects for the moral, spiritual, and economic upliftment of probationers, parolees, pardonees, and first-time minor drug offenders utilizing available community resources. All offenders granted probation, parole, pardon, and suspended sentence. The administration has adopted a harmonized and integrated treatment program for these clients to affect their rehabilitation. So all offenders were granted probation, parole, and suspended sentence. These harmonized and integrated programs involves the therapeutic community modality, the restorative justice principles and concepts, and third, the use of volunteer probation aids or the VPAs. The therapeutic community modality is a self-help social learning treatment model used for clients with problems of drug abuse and other behavioral problems such as alcoholism, stealing, and other antisocial tendencies. As a treatment model, it includes 4 categories, namely behavior management, intellectual or spiritual aspect, emotional and social aspects, and vocational or survival aspects. In this regard, the therapeutic community modality provides a well-defined structure for a synchronized and focused implementation of the various intervention strategies and activities undertaken by the agency, such as individual and group counseling. So, individual and group counseling, this activity intends to assist the clients in trying to sort out their problems, identify solutions, reconcile conflicts, and help resolve them. And this could be done either by individual or group interaction with the officers of the agency. Second is the moral, spiritual, and values formation. Seminars, lectures, or trainings offered or arranged by the agency compromise these rehabilitation activities. Active NGOs, schools, civic, and religious organizations are tapped to facilitate the activities. Third is work or job placement referral, categorized as an informal program wherein a client is referred for a work or job placement through the officer's own personal effort, contact, or information. So they provide also work or job placement referral to the prisoners. Vocational or livelihood and skills training. So the program includes the setting up of seminars and skills training classes like food preservation and processing, candle making, novelty items, and handicrafts making to help the clients earn extra income. So they were also taught to make classes of food preservation and processing, candle making, novelty items, and handicraft making. So this is a vocational or livelihood skills training inside the prison or the correctional institutions. And likewise, vocational and technical trades classes are availed of, such as refrigeration, automotive mechanic, radio, television, and electronics repairs, tailoring, dressmaking, basic computer training, and through coordination with local barangays, parish centers, and schools and civic organizations. Health, mental, and medical services. To address some of the basic needs of clients and their families, medical missions are organized to provide various forms of medical and health services, including physical examination and treatment, free medicines and vitamins, dental examination and treatment, drug dependency test, and laboratory examination. So prisoners inside the prison were also provided various forms of medical and health services, such as physical examination, treatment, free medicines, vitamins, dental examination and treatment, drug dependency test, and laboratory examination. Psychological testing and evaluation, as well as psychiatric treatment, are likewise provided for by the agency's clinical services division, and if not possible by reason of distance, referrals are made to other government accredited institutions. So they were also checked by psychiatrists and provided psychiatric treatment. Next is the literacy and education. In coordination with LGU programs, adult education classes are availed of to help clients learn basic writing, reading, and arithmetic. Likewise, literacy teach-ins during any sessions conducted for clients become part of the module. This is particularly intended for clients who are no read, no write, to help them because functionally literate. So, they also offer education for those who were illiterate. Next is the community service. This program refers to the services in the community rendered by clients for the benefit of society. It includes tree planting, beautification drives, and cleaning and greening of surroundings, maintenance of public parks and places, garbage collection, blood donation, and similar socio-civic activities. Next is the client help self-help organization. So this program takes form of cooperatives and clients associations, wherein the clients form of cooperatives as an economic group to venture on small-scale programs or projects. And similarly, clients associations serve another purpose by providing some structure to the lives of clients, where they relearn the basics of working within a group with hierarchy, authority, and responsibility, much like in the bigger society. Next is the payment of civil liability. The payment of civil liability or indemnification to victims of offenders are pursued despite the economic status of clients. Payment of obligations to the victims instills in the minds of the clients their responsibility and the consequences of the harm they inflicted to the others. So they are still obligated to, the prisoners are still obligated to pay the harm or the consequences they have dealt to the victims. Next is the environment and ecology. To instill awareness and concern in preserving ecological balance and environmental health, seminars, lectures are conducted wherein clients participate. These seminars, lectures tackle anti-smoke belching campaign, organic farming, waste management, segregation and disposal, and proper care of the environment. So, prisoners were also taught to how to and taught to protect and preserve the environment by proper disposal of the garbage and organic farming. So they also attend seminars or lectures. Next is sports and physical fitness. Activities that provide physical exertion like sports, games, and group play are conducted to enhance the physical well-being of clients. Friendly competition of clients from the various offices of the sectors together with the officers provide an enjoyable and healthful respite. So prisoners were also allowed to play sports and do physical fitness, to conduct physical fitness at the prison. Two systems-based approaches to corrections. Corrections refers to the supervision of persons arrested for, convicted of, or sentenced for criminal offenses. Correctional population fall into two general categories: institutional corrections and the community corrections. Corrections data, with a few exceptions, covers adult agencies or facilities and adult offenders. BJS maintains over 30 corrections-related data collections. Most are annual collections of administrative data from correctional administrators, ranging from basic population counts and offender demographic characteristics to facility, capacity, program, staff, and resources. These data collections include National Prisoner Statistics, or the NPS program, or the administrative data on state and federal prisoners collected twice a year, and the Annual Survey of Jails, or ASJ, administrative data on jail populations, Annual Probation Survey and Annual Parole Survey, administrative data on offenders under community supervision. Next is National Corrections Reporting Program, or the NCRP, administrative data on admissions to and releases from state prisons collected annually from the participating state jurisdictions. Census of jails and census of state and federal adult correctional facilities, administrative data on facilities and staff collected periodically. The Justice Expenditures and Employment Extracts, or the JEEE, administrative data on federal, state, and local government expenditures and employment for correction activities. The NPS also collects counts on specific inmates populations from the Department of Defense, or DOD, and the U.S. territories. Some limited information on the number of juveniles held in adult facilities is also collected in the NPS and the ASJ. Jails in Indian country is a separate collection for data on counts and characteristics of persons held in tribal jails. So in India they also have tribal jails that is separated from the from their correctional institutions. BJS also tracks administrative data on other topics such as HIV in correctional facilities, death in custody, sexual assault in correctional facilities, and capital punishment statutes, populations, and executions. So the Bureau of Corrections, Republic Act number 10575 or the Republic Act number 10575, otherwise known as the Bureau of Corrections Act of 2013, for the purpose of prescribing and applying the necessary rules and regulations for the strengthening of the correctional services. So, the declaration of policy. It is the policy of the state to promote the general welfare and safeguard the basic rights of every prisoner incarcerated in our national penitentiary. And the Bureau of Corrections, or BUCOR, is charged with custody and rehabilitation of national offenders, that is, those sentenced to serve a term of imprisonment of more than 3 years. So, Director General refers to the highest officer in the BUCOR, with the rank of Undersecretary as a civilian employee in the uniformed service who is authorized to wear the 3-star rank insignia as symbol of authority and command responsibility. So the highest authority of BUCOR is the Director General. And Carpeta. What is carpeta? So, refers to the institutional record of an inmate which consists of his mitimus or commitment or order issued by the court after conviction, the prosecutor's information, and the decision of the trial court and the appellate court, if any, certificate of non-appeal, certificate of detention, and other pertinent. So, custody. To have custody of a prisoner, a state or the Federal Bureau of Prisons or the BOP must physically hold that person in one of its facilities. A locality, state, or the BOP may hold inmates over whom a different government maintains jurisdiction. The safekeeping. So, safekeeping, which is the custodial component of the BUCOR's presentation correction system, shall refer to the act of that ensures the public, including families of inmates and their victims, that the national inmates are provided with their basic needs, completely incapacitated from further committing criminal acts, and have been totally cut off from their criminal networks or contacts in the free society while serving sentence inside the premises of the National Penitentiary. So they gave us assurance to the families of the inmates and their victims that they will be rehabilitated and totally cut off and will be changed inside the correction institution that they were in. So, this act also includes protection against illegal or organized armed groups which have the capacity of launching an attack on any prison camp of the National Penitentiary to rescue their convicted comrade or to forcibly amass firearms issued to prison guards. So the act also protects the correctional officers inside for those people who plans to attack or rescue their comrades and get them out from prison. And reformation, which is the rehabilitation component of the BUCOR's present correction system, shall refer to the acts which ensure the public, including families of inmates and their victims, that released national inmates are no longer harmful to the community by becoming reformed individuals prepared to live a normal and productive life upon reintegration to the mainstream society. So reformation. So this is the main component of the BUCOR's present correction system, rehabilitations. So they make sure that that the prisoners inside are rehabilitated, and they also ensure that once they go out to the mainstream society, they they are changed people, and they are already reformed, and they are not the people they were before. Next is the security and control of prisoners. So prison security is a crucial to maintaining staff and inmate safety in a correctional setting. Security in prisons includes but is not limited to managing restrictive housing populations, classification and assessment, managing special populations, and security audits. Operation Operations of the Bureau of Corrections. The Bucor shall operate with directorial structure. So they follow structures, and it shall undertake reception of inmates through its Directorate for Reception and Diagnostics, or the DRD, formerly Reception and Diagnostics Center, or the RDC, provide basic needs and security through its Security and Operations Directorates, administer reformation programs through reformation directorates, and prepare inmates for integration to mainstream society through its Directorate for External Relations, or the DER, formerly External Relations Divisions, or the ERD. So they follow direct orders from their directorates of the reformation. Care and treatment of prisoners. So it is the policy of the state to promote the general welfare and safeguard the basic rights of every prisoner incarcerated in our national penitentiary. It also recognizes the responsibility of the state to strengthen government capability aimed towards the institutionalization of highly efficient and competent correctional services. So they also ensure the welfare and the general welfare, and to safeguard the basic rights of every prisoners who were incarcerated in the national penitentiary. Towards this end, the state shall provide for the modernization, professionalization, and restructuring of the Bureau of Corrections by upgrading its facilities, increasing the number of its personnel, upgrading the level of qualifications of their personnel, and the standardizing their base pay, retirement, and other benefits, making it at par with that of the Bureau of Jail Management and Penology. So the Bureau of Corrections personnels were their base pay were standard, just like the BJMP, and their retirement and other, they also have the retirement benefits and other benefits. Release of prisoners' good conduct time allowance. So Republic Act 10592, or the Good Conduct Time Allowance, or the GCTA law, allows for a reduction of sentences of persons deprived of liberty depending on how well they abide by rules and regulations inside any penal institution, rehabilitation, or detention center, or any local jail. So the persons deprived of liberty means those prisoners, and with their good conducts or behavior inside the prison, they were granted and allows for a reduction of sentences. if they show good behaviors. And this law in relation to Republic Act 7659 death penalty law reportedly does not cover PDL who have been convicted of heinous crimes and enumerated in RA 7659. These crimes were considered punishable by death for being grievous and odious and hateful offenses, and which by reason of their inherent or manifest wickedness, viciousness, atrocity, and perversity are repugnant and outrageous to the common standards and norms of decency and morality. The application of the GCTA law resulted to the supposed erroneous release of at least 1,914 inmates, a large majority of which already surrendered or returned to government custody at the behest of President Duterte. So there are 1,914 inmates who were released because of the GCTA law, but still they surrendered and go back to the prison custody. Prohibited acts subject to disciplinary actions. The disciplinary regime established the rules of prison life by listing breaches of the international regulations and the sanctions associated with this. The existence of disciplinary procedures is essential to both the maintenance of order within prison establishments and respect for the basic human rights of persons deprived of liberty. So disciplinary actions is required in the prison, and order must be in the existence inside the disciplinary, and the procedure is essential for both maintenance and order of the prison. Detainees must be familiar with the disciplinary rules, and this must be respected by prison authorities. Sanctions for each offense must be provided for in law. Recourse to disciplinary sanctions must be a last resort, and detainees must see that their right to fair treatment is respected. So detainees must also be aware of that law, and so the authorities will not abuse them or abuse their rights, because some cases there are personnel who abuse the prisoners. The disciplinary system in place is an essential component of security. It enables prison lives to be organized and regulated by identifying behaviors which constitute infringements to the rules of communal life, and by establishing sanctions in case these rules are violated. Disciplinary sanctions which resembles forms of ill treatment as well as those arising from any kind of discrimination are forbidden. The sanctions must be understood by the detainees and implemented by the authorities, above all as a way of ensuring order and security, and not as a punishment for deviant behavior. The BJMP, or the RA number 6975, was, and on December 13, 1990, an act establishing the Philippine National Police under a reorganized Department of the Interior and Local Government, and for other purposes. So the Republic Act number 6975 established the Philippine National Police, or the PNP, under a reorganized Department of the Interior and Local Government. So this law stated that the PNP is supposed to have maritime police unit to absorb the police functions of the Coast Guard and to be provided with a sea capability. So they also provide, so this so so in the law it stated that the PNP is supposed to have a maritime police unit that will guard the coast and the sea. Declaration of policy. It is hereby declared to be the policy of the state to promote peace and order, ensure the public safety, and further strengthen local government capability aimed towards the effective delivery of the basic services to the citizenry through the establishment of a highly efficient and competent police force that is national in scope and civilian in character. Towards this, and the state shall bolster a system of coordination and cooperation among the citizenry, local executives, and the integrated law enforcement and the public safety agencies created under this act. The Republic Act 9263 or the Republic Act, otherwise known as the Bureau of Fire Protection or the BFP, and the Bureau of Jail Management and Penology or the BJMP Professionalization Act of 2004, upgraded among others the qualification standards in the designation of the uniformed personnel and these agencies. So this act professionalized the BFP and the BJMP, these agencies. An act providing for the professionalization of the Bureau of Fire Protection and the Bureau of Jail Management and Penology, amending certain provisions of Republic Act No. 6975, providing funds thereof and for other purposes. The BFP was formed from the units of the Integrated National Policies Office of Fire Protection, service on January 29, 1991 through Republic Act No. 6975, which created the present Interior Department and placed the provision of fire services under its control. So, the Bureau of Fire Protection is responsible for the prevention and suppression of all destructive fires in buildings, houses, and other structures, forests, land transportation, vehicles, and equipment. Ships or vessels docked at piers or wharves are anchored in major seaport, petroleum industry, and installation. So, the Bureau of Fire Protection, so they are the ones who the Bureau of Fire Protection, they're the ones responsible for the prevention and suppression of the destructive fires. So they are the ones who were tasked to put off fire accidents or any fire incidents. So treatment of special needs and unusual offenders. So special offenders includes women offenders, drug addicts, alcoholics, mentally ill persons, and sex deviates, and escape-prone prisoner, suicide risk prisoner, the handicapped, aged, and infirm youth offenders, and alien inmates. So all prisoners shall be treated with the respect due to their inherent dignity and value as human beings. So there shall be no discrimination on the ground of race, color, sex, language, religion, political, or the opinion and national or social origin, property, birth, or other status. Emergency plans. Keeping correctional staff safe begins with how we prepare to respond to correctional emergencies. This preparation is usually dealt with under the umbrella of emergency preparedness planning. So there are incidents or accidents that occur sometimes and not intentionally inside the prisons or the correctional facilities. And so emergency plans were made. It is important to note that correctional personnel respond to emergencies as first responders. Staff members initially respond to these emergencies, determine the type of specialized emergency response is needed, then assist with handling the problem with while the appropriate specialized response teams are called to the scene, such as the Correctional Emergency Response Teams or the EMS, Fire Department, or Maintenance Department. So there are many departments that were called to provide help if emergency were needed. So emergency managers think of disasters as recurring events with four phases: mitigation, preparedness, response, and recovery. The following diagram illustrates the relationship of the four phases of emergency management. So, types of correctional institution emergencies. There are four types of emergencies. First is the disturbance emergencies. So, these range from the daily arguments between inmates and other inmates and or staff to fight self-harming behavior from minor disturbance through a major riot. This this includes fights 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 between inmates or gangs inside a prison, and these these small fights will might become a major riot and involves many prisoners. Next is the medical emergencies. So this range from a small cut on the finger to major injuries from natural cause and or fights to major medical problems like a heart attack or suicide attempt. Next is fire emergencies. Fire are always concerned concerned because of the danger of direct fire and the smoke generated by the fire, along with the accompanying panic response. Miscellaneous emergencies. This category is a catch-all for all other emergencies that occur in a correctional environment and deals with such as power outages, heating and AC system failures, or plumbing emergencies that generate flooding. Next is the movement, transfer of prisoners or detainees, privileges of detainees or sentenced prisoners. So, transfers of sentenced prisoners or persons agreements or the TSPAs facilitate the successful reintegration of sentenced persons into society and ensure their effective rehabilitation as they are afforded the opportunity to serve their sentence in the country of their nationality. And transfer may be requested either by the sentencing state or administering state. A transfer shall be effected only upon the consent of the sentencing state, administering the state, and sentenced person. A sentenced person transferred under TSPA may not be arrested, committed for trial, or convicted in the administering state for the same offenses or offense for which he or she was sentenced. A sentenced person transferred may not be arrested, committed for a trial, subjected to any restriction of his or her personal liberty on account of previous acts that are different from those which gave rise to his or her transfer. The Regional Rehabilitation Center for Youth, or the RRCY, is a facility designated to provide intensive treatment in a residential setting for the rehabilitation of CICL whose sentences have been suspended. It serves as a nurturing out of home placement for children in need of rehabilitation. While the RRCY provides institutional rehabilitation for the CICL, community-based rehabilitation programs are also being provided by the DSWD. Yes, the DSWD is also involved with this treatment because the children's is also part of their jurisdiction when it comes to children, and whenever necessary the RCCY links its center-based service to community-based programs for the programs provided in a community setting development for the purpose of intervention and diversion, and from formal court proceedings as well as rehabilitation of the CICL for final reintegration into his family and community. The support and participation of the immediate family and community is valuable. Hence, RRCY harnesses the community support structures outside of the family. And community structures are tapped and mobilized to contribute their resources to the treatment and reintegration of offenders and strengthening their families. General objective. So this general objective is to render treatment and rehabilitative services to children in conflict with the law or the CICL in the Cordillera Administrative Region or CAR to enhance their psychological, emotional, and psychosocial well-being. The Child and Youth Welfare Code, Presidential Decree Number 603, otherwise known as the Child and Youth Welfare Code, and issued in December 1974, legally defines special categories of youth, including the youthful offenders, and direct the Ministry of Social Services and Development or the MSSD to provide comprehensive services to assist in youth development. Even before this decree, the MSSD had implemented an integrated human resource development program for youth of IHRDPY encompassing the three program areas: economic self-sufficiency, community responsibilities, and youth with special needs. The goals of the IHRDPY were to encourage positive social and cultural values, to stimulate youths to engage in economically productive activities, to protect the vulnerable youth such as delinquent and the handicapped, and to provide support to non-government youth programs. And the MSSD views delinquency as a community problem. Consequently, the ministry through the DPY provides for the intervention of MSSD social workers with law enforcement agency, the courts, and the other agencies to prevent further involvement of offenders in the criminal justice system and to reintegrate them into the community. So the MSSD and the IHRDPY are the ones working and ensuring the rehabilitation of children who were part of delinquency, and so they will not be involved in criminal crimes when they are back in the community. So the death row, capital punishment in the Philippines, or the Filipino parusang kamatayan sa Pilipinas. The Philippines has a long and varied history of the capital punishment, existing throughout its entire history from pre-Hispanic period until its formal independence in 1946, but it was most recently suspended in the year 2006 and replaced with a reclusion perpetua for crimes that falls under the revised penal code and life imprisonment, provided by other special laws for crimes not included in the former. In 1946, murder, rape, and treason were grounds for the death penalty. Until 1961, 51 were sentenced to death by the law. This number scored high under the presidency of Ferdinand Marcos. Under the administration, drug trafficking was added to the list of crimes punishable by death. So until 1961, 51 were sentenced to death by the law under the administration of Ferdinand Marcos. And electric chair were the primary instrument for the execution during Marcos's time, and inherited from the United States after its 46-year colonial rule in the country, then replaced by firing squads in 1976. So when Marcos was overthrown during the 1986 People Power Revolution, the Philippines became the first country in Asia to abolish death penalty by virtue of the 1987 Constitution, where it struck down the sentence for existing death row inmates but not necessarily prohibiting them, the government from reinstating it under Article 3 of Section 19. And the death penalty was reinstated under the rule of the President Fidel Ramos, which used lethal gas inhalation to dispense the judgment. Executions continued until the second suspension of the death penalty under President Gloria Macapagal Arroyo, who suspended it under the Republic Act number 9346 in 2006. So under President Ferdinand Marcos, he used the electric chair for the execution, and under President Fidel Ramos, he used the lethal gas inhalation, but was later suspended by President Gloria Macapagal Arroyo under the Republic Act number 9346 in 2006. So this is the lethal gas inhalation execution chamber. So this is the chamber. This is where the prisoner was put. Death to capital punishment. The recent withdrawal for support by the Senators Panfilo Lacson and Emmanuel Pacquiao for the imposition of the death penalty further dooms the revival of the capital punishment in the 18th century. So the withdrawal of support by Senators Panfilo and Emmanuel Pacquiao for the reimposition of the death penalty further dooms the revival of the capital punishment in the 18th century Congress. And the revival of the capital punishment is among the priority measures of the President Rodrigo Duterte. In fact, pro-Duterte legislators filed House Bill 001 for the restoration of the death penalty. And 7 bills on the reimposition were filed in the previous 17th Congress in the House of Representatives. These bills were consolidated as HB 4727, whose approval was railroaded but did not hurdle the Senate, where 8 identical bills were also pending. And 12 bills were reintroduced in the House this 18th Congress for the revival of the capital punishment, all of which are languishing in the Committee on Justice because of steadfast and vigilant opposition of anti-death penalty advocates. And no light is seen at the end of the tunnel for similar bill in the Congress, in the Senate. The role on the writ of amparo. So the petition for a writ of amparo is a remedy available of any person whose right to life, liberty, and security is violated or threatened with violations by an unlawful act or omission of a public official or employee or of a private individual or entity. And the writ shall cover extra-legal killings and enforce disappearances or threats thereof. The right of amparo is a legal procedure to protect human rights. So this law also protect the human rights. Under its new legal remedy, state authorities can no longer use as a defense that they do not know where the missing persons are. And Section 17 of the rule on the writ of amparo specifies the degree of proof required from the petitioner as a respondent name in the petition for the writ of amparo, to which Section 17 burden of proof and standard diligence required. The parties shall establish their claims by substantial evidence. And that's all.